Good morning, this is Nick Augustine with Mark Scroggins. We're here at Scroggins Law Group in Dallas, Texas, and we are talking all about issues with moving kids out of state.
Hey Nick, how you doing?
Pretty good, how are you, Mark?
I am good.
All right, well, let's talk a little bit about what happens when maybe we are, I guess we could be in the middle of a divorce and considering a move out of state, or after a divorce, someone gets a new job, there's a new someone in someone's life, all sorts of reasons that people move.
Right.
And so today we're going to talk a little bit about what happens when we're looking at moving kids out of state. So let's talk about some of the reasons that people have to move.
Well, generally around the time of divorce, when you see somebody who typically wants to move, that generally is because maybe they don't have a bunch of familial support where they currently are, and they want to go to a place where they've got that family support. Maybe they haven't been working during the pendency of the marriage, and they're going to have to work now, and so they need, some assistance with pick up, drop off, and just being able to assist with the kids during their times of possession. So you see that happen a lot. The stuff that you initially were talking about, job and all of that, that generally doesn't come into play during a divorce. It can, if it just so happens to coincide with that. Maybe you've got someone who's a consultant, and they've got a gig that's going to take them for an extended period to another place. That can come into play, but that is typically where someone is actually moving for a job. That is something that typically you would see more in a modification case, but that's, it comes up all the time, and it's not so easy to deal with. There are just a lot of different factors.
Right. Well, in the last time we talked a lot about the exclusive right of determining the residence of the kids. So these are, and if that sort of, whether there's a thing that someone's going to move, is that kind of foreseeable?
Well, it depends. So generally, here's the difference, okay? Typically, if someone is named a sole managing conservator, you get the exclusive right to establish the primary domicile of the child, just like a joint managing conservator does. The difference is, typically, okay, there's not going to be a geographic restriction if you are named sole managing conservator. So with that, that means that you've got the ability to up and move whenever you would like, regardless of the other person's involvement. The big difference with a joint managing conservator is typically there is going to be a geographic restriction. And that restriction most of the time is going to be, that county. So let's say somebody's getting divorced in Collin County, okay? So typically that geographic restriction is going to be Collin County and other counties that are contiguous to it or that touch that county.
Right.
Okay? So it doesn't always mean that it's going to be that. It could be specific counties. Let's say, it could be Dallas and Tarrant County, okay? It could be a situation where something is just done down to a particular school district or even a particular school. So it can be done a whole bunch of different ways, but if you're trying to change that so that you've got the ability to move, you better have a damn good reason, unless the other parent just really isn't involved.
Well, you're talking about modifications, you're talking about a whole new case.
That's correct.
Right.
Yeah.
So that's a little bit more than just, hey, judge.
Yeah. There's no way to do that. Any change that you make to an order, you and your former spouse can agree to whatever the hell you want to agree to. Okay. But if you're fighting about it, you're going to have to go get a new order, and going and getting a new order is not as simple as just, filing a motion. You are filing a new lawsuit. So it is a petition to modify the case. And so, there are a lot of different things that are going to happen.
Even if everyone agrees.
Well, you still are going to have to file a modification if everybody agrees. The thing that you don't have is you don't have the waiting period like you do in a divorce. That, you've got 60 days after it's been filed. In a modification, you could file it and file the order the next day and be fine. Which I would suggest that if you and your former spouse are in agreement, you still want to do something like that. Because if all of a sudden someone gets their nose out of joint you know, I've seen it happen all the time. No, we didn't have any agreement. You know, he just up and left, or she just up and left, and you know, now I can't be mom or I can't be dad.
Yeah.
So you better be damn sure that you've got that documented.
Absolutely. All right, let's shift gears. Let's talk about what happens when I want to prevent my spouse from moving. Let's say, I'm just going to throw you a hypothetical. My ex-wife is a nurse.
Right.
And she's worked at Baylor Scott and White for so long. Everything's great. But now she wants to go and, you know, move and take a new nursing job. That's a definite opportunity. But it's far away. And I know that the reason behind it is this new guy she's seeing down in San Antonio.
Well, so the important thing to...
Can I stop them?
Well, maybe. I would say in that particular scenario, the answer is probably, okay, because there are a wealth of nursing jobs in the Metroplex. So, you know, the inability to get a job like that isn't really going to play into it. And so it's going to be difficult to convince the court that that's the reason that you need to move, okay? Where you see this more often than not is, let's say someone is a high-level manager in a company, okay, or is a C-suite executive, you know, a CEO, a CFO, a CMO, a COO, all the different O's, okay? Those jobs don't just grow on trees, and so it is not uncommon to say somebody has been working, you know, in that position at one of the many companies in North Texas, but all of a sudden he gets an opportunity, or she gets an opportunity that's in California, or that's in New Jersey, or New York, or Florida, or Ohio, or something like that. That's when you have a real argument about it, okay? And still, even if that is a great job for the person who has the exclusive right to designate the primary residence of the children, you still have to show that it is in the kid's best interest. And it's not a rubber stamp situation. I mean, so let's say that this is dad wants to move with the kids to Ohio, okay? So first you need to find out why. Why is dad moving? You know, he's got a better job offer. Okay, how much better? You know, is he making $5,000 a month more, or a year more? Is he making $5,000 a month more? Is he making $10,000 a month more? What kind of position were they in financially, he and the kids, here? Okay, how involved has he been with the kids? Now here's the big thing. How involved has mom been? You know, is she exercising all of her possession? Is she involved in extracurriculars with the kids? Does she have more time than what is laid out in the parenting plan? If she doesn't, is that because the other side doesn't allow her to get more, or she hasn't requested more? What kind of things do the kids do? What kind of relationship do the kids have? What are the ages of the kids? How bonded or attached are they to mom and to dad? Are there learning disabilities of the kids? Are there things that they will be able to get with this added amount of income that dad has that they could not get here? How does that improve their life? How does that balance out against mom being involved?
Lots of factors, Mark.
Yeah, that's my point.
You know, I think the takeaway may be, even though it may look like an open and shut deal.
Well, and let me stop you right there. There's no such thing as an open and shut deal unless y'all both agree.
Right.
Okay? Otherwise, there's not. It's just not. So, you know, if you and your former spouse agree, then it's open and shut. Okay? If you don't, which is the whole reason that you're coming and talking to a lawyer about it, because y'all don't agree, it's not open and shut. And it's not going to be. Okay? Because money is not the defining factor. Okay? It is a big factor, but it's not the defining factor. I mean, you have to be able to explain to the court, why is it in the children's best interest? You know, so what could happen otherwise? Well, the court could say, take your job if you want, but the kids are staying here. Yeah. And that happens.
All right, Mark, we talked a little bit about moving for a new job for many reasons, about trying to prevent your spouse from moving if that's appropriate and what the situations are. Let's talk a little bit about backing up and how we got to these rights of who has the right to move a kid out of state.
Well, I mean, it depends on if there's a geographic restriction. Okay, so you know, we've talked about conservatorship before and possession and access, and so to back up, possession and access is exactly what it sounds like. It's the amount of time that you have with the kids, and conservatorship are the rights and duties that each parent has as it relates to child rearing decisions. One of those is the exclusive right to designate the primary domicile of the children. Okay, now if someone is named a sole managing conservator, like I was mentioning before, typically you are not going to have a geographic restriction. So that person, a sole managing conservator, generally, unless there is for some strange reason a geographic restriction, is going to be able to up and move the kids, you know, whenever he or she wants to. Okay, if the parents are named joint managing conservators, even though that parent has the exclusive right to designate the primary domicile, typically there's going to be a geographic restriction, like I was talking about earlier. You know, and typically that is going to be that county. So let's say Collin and counties contiguous to Collin. Okay, so in that regard, no one can move the kids. You have to ask the court for permission. So you are asking the court to lift the geographic restriction.
Right.
So,
so what then? So let's talk about the court keeping jurisdiction over children. And I'm thinking of situations where maybe we're in Denton County and the other job is in Oklahoma City.
Sure. Well, and that can happen. I mean, you know, so those are easier to deal with, okay?
Or California.
Well, that's more difficult to deal with, okay? And that's where all those things that I just mentioned a little bit ago, all those different factors are going to play in. If you're talking about somebody who, you know, lives in the Metroplex, all right, and they're looking at moving to Oklahoma City, let's just say it's an oil and gas gig, okay? And they want to go up there. It is still governed by, in the parenting plan, you have two different pieces on the possession and access, okay? You have the stuff that is laid out for when parents reside under 100 miles apart from one another. And then you have another that is when parents reside over 100 miles, okay? When you live relatively close, you know, a couple 100 miles, okay? That's still a pain in the butt getting back and forth. But let's say somebody's in Denton County, going up there, and maybe it's closer to 150 miles, okay? Something like that. So what can be done? Well, you know, the court's going to look at, you know, is going to evaluate all those factors that I mentioned. You know, what's the reason for the move? What's the impact on the kids? What are the ages of the kids? How entrenched are the kids in their school system? So, you know, if you've got a kid who's coming up on their junior or senior year of high school, you know, that's a hard one. You know, you really have to show an incredible benefit. If the kids are, you know, 3 and 5 years old, that's different.
Right.
You know, it also is going to depend on how involved have they been. So there, you kind of look at things a little differently once you get teenagers as compared to when you've got a 3 and a 5-year-old, because that, you know, that bonding is still going on. So it's so important that you be able to see the kids with a large amount of frequency. Well, if you accept a job to go work for Microsoft, you know, up in Seattle, guess what? It's freaking hard to, you know, see the kids at all, much less the, you know, once a month that is laid out in a possession schedule for over 100 miles. Now, the benefit is you've got 42 days during the summer, so that's great. But, you know, during the school year, man, except for, you know, the holidays, it's rough. You know, you don't get to see the kids very much. So you've got to really evaluate all of those issues. Now, let's talk about something else too. We're very lucky in North Texas that we have had all this influx of new business, okay? You know, new corporate headquarters. There was just an article in the you know, in Dallas Business Journal recently about they finalized that McKesson is coming here from California and is going to set up their headquarters in Las Colinas. Okay, you've got the PGA that's coming to Frisco, you know, here in a couple years. All that is being built and developed. You've got all these other corporate headquarters. Okay, So when you have people that come in here, and this obviously applies going the other way. So what happens in a lawsuit involving jurisdiction over the kids? That is a common question, okay? So luckily, there's what is called the UCCJEA, and that governs those types of things, okay? And in a situation like that, the court here, let's say that they moved from California, okay? Let's say they moved from California a year ago, okay? And so you've got a California order, all right? Well, a Texas court can establish jurisdiction in that regard. And they do it under the UCCJEA, and it talks about how it's done, and you register what is called a quote-unquote foreign judgment, okay? And the other side has 20 days to, object to it or set a hearing and all of that. If not, then it is registered as a Texas order, and then we can begin the modification process related to that. Now, where you run into interesting questions is when they haven't been here for 6 months to establish jurisdiction, but they have been here for 3 months, okay? So then, what happens? And that's a whole convoluted issue, okay? Because the court here can establish emergency jurisdiction over the child if there's a risk of significant impairment like you have in so many other child issues. So in that case, the court can step in and exercise jurisdiction and say, I'm going to maintain jurisdiction over this while we figure out what to do, okay? And then it requires that the Texas court and the California court continue to have communication about, I shouldn't say continue, have communication about where should this lawsuit rise, because every case, when you get a divorce and there are kids involved, that court is called the Court of Continuing Jurisdiction. You can either maintain a case there, or you can seek to have it transferred, okay? So in the situation where I was talking about, you would file a motion to transfer when jurisdiction has been established. When you don't meet the jurisdictional requirements, the UCCJEA is going to come involved, and between the Texas court and the California court, or whatever court that is, they're going to make a determination of which court has jurisdiction, which one should maintain jurisdiction, and there are different ways that the Texas court could punt it back to California, or those two could talk and decide that actually Texas should retain jurisdiction of the case. So there are a lot of moving parts on that, much more than I can really go into in 5 or 10 minutes on a video podcast.
Yeah, there's a lot there, and I've been seeing more where I've talked to people who have moved to the area and their ex-spouse has also moved and got a job, and so where it seems it wasn't people had the inability to move. I mean, the jobs are plentiful, and if you're the whole family's moving.
Yeah, that happens more and more.
I'm seeing it. At first I thought, wow, that's interesting. And then I started hearing more and more about that.
Yeah, it's been happening a lot in Texas just because the job market has been so good and our unemployment rates are so low. We've got a case going on. We've got a couple of cases going on like that right now where dad followed mom to Texas, so that he could exercise possession.
Yeah.
So that makes it easy as far as figuring out the jurisdiction. The ones where it's really difficult is when it's been under 6 months.
Sure. All right. Well, so people who want to know more, they are in a divorce, they have been divorced, they've got issues, people are moving, there's job opportunities, they want to know what they're up against. What's their best course of action, and how do they get in touch?
Well, first you always want to reach out to a lawyer, and I would suggest give us a call. You can reach me at the office, 214-469-3100. That'll get me in any of our offices. Or you can just send me an email directly at mark@scrogginslawgroup.com.
All right. Well, we thank you all for listening, and please do share this podcast as you find it on your social media or wherever, because you just never know who your neighbor next door could have these exact issues, and you just never know.
Exactly.
All right. Well, thank you all.
Thank you much.